All right, I think we're ready to get started. My name is Carrie Williamson, and I am a partner at DLA Piper. This is our office. I'm also the deputy office managing partner in the Palo Alto office. We like to welcome you to our relatively new offices. We just moved in October, and we're really excited to have the opportunity to host Spoodle and this fantastic event this year, and continuing from last year. So one of the reasons why it's really important to me personally and DLA Piper overall is to support students and give them a pipeline of knowing what is possible and give them the tools to reach their ultimate goals when they may not even know that a path may be out there for them. And so that's something that I'm really passionate about, and part of the reason why I got involved with Spoodle and joined the board. And DLA Piper is as well. We have a signature pro bono project of advancing education's promise. And so we're really excited to be able to continue to support the Moot Court event through Spoodle. So with that, I know the main event is waiting, and I'd like to pass the baton to hear about the about your experiences within Silicon Valley Urban Debate League.
Okay. Hi, everyone. My name is Nejma Ali. I am a current program specialist for the Silicon Valley Urban Debate League, and I'm also an alum of the program. I started debate my sophomore year in high school and have been involved with the program very deeply. I've went to almost every opportunity Spoodle has offered me during my time as a student. I got really excited. I got hooked on debate. I went to most internal tournaments. I went to a bunch of travel tournaments. I went to a lot of law firm visits, and even competed in Spoodle's Moot Court in 2018, similar to what the students are doing here today. And I've always had a personal sense of advocacy and understanding of social justice issues, but Spoodle has equipped me with my skills to be more persuasive, to break down arguments, to understand the premise of people's words, and to be able to respond clearly and effectively. My personal experience with speech and debate has sparked my interest in a career in law and has made me think of it as a possibility and understanding as a possible trajectory that I can look forward to in my personal life. And just recently, a week ago, I had committed myself to University of San Francisco School of Law, and I will be starting this fall. But today we are here to witness and give time for the 4 students who have dedicated a good amount of their school year and their extracurricular time where they could have been maybe having fun or doing more social things, but we understand where students sometimes want to do something that can better their future, or understanding where they want to better their own personal skill set. So I will pass the mic down to Kojo to get us started.
Let's give another round of applause for Nejma. Thank you so much, Nejma. We're so proud of you, and thank you so much for working with us. Nejma was one of the first people I recruited with the rest of the Silicon Valley Urban Debate League from Oak Grove High School. She was amazing when she was in the classroom saying, "Oh, so this is what you think? Well, what about this?" And arguing, about some silly joke, some silly topic. And this is an example, I think, of how important the work that we're doing here, and the time that the justices are here with us, the time that you all are here with us, the time that the lawyers have spent. We really appreciate everything that everyone has done to help make this an opportunity for our students. I am amazed and impressed at the students and with the students, and I'm sure you will as well. They've spent a ton of time preparing for this, and I know they're going to rock your socks. So before we get started, I want to give a little bit of background information. First, we are dealing with a fictitious case. This fictitious case is about an individual named Casey Davidson. He is being charged with murder. And he's being charged with murder because of someone's death, of course. And so the issue at heart of this pretrial motion is whether or not some evidence should be admitted into the actual court case. And so the defense is going to argue, well, no, we shouldn't do that. And the prosecution will say, well, yes, we should be allowed to have that here. And so we have with us today Judge Michelle Friedland from the Ninth Circuit. Sorry. We have Justice Lee from the 11th District in California. 11th District. 6, I'm so sorry. From the 6th District. And we have Justice Wilson as well from the 6th District. And they are here to preside over the case and get us started and get us going. And we thank you all so much. We also have our students from, I'm going to go from left to right. We have Hilda Huynh from Independence High School on the defense. We have Michelle Lee from Silver Creek High School on the defense. We have Isabel Ranke from Independence High School, also on the prosecution, sorry. And we have Ria Tiagi from Mount Pleasant High School, also on the prosecution. Okay, so let's get it started. Judge Friedland, would you please get us started?
Yes, thank you all for being here today. Today we'll be hearing the case of People versus Davidson. And when the attorneys are ready, we are ready to hear from you.
Good afternoon, Your Honor. May it please the court. My name is Hilda Huynh, and I represent Casey Davidson along with my co-counsel, Michelle Lee. My client requests to exclude the use of the GPS data showing the location of Mr. Davidson's car near Thompson's home because it was not a legal search under the Fourth Amendment for the government to obtain GPS location data from a third-party GPS provider. The conflict at large relates to the two political groups present at the rally for Mitchell Kennedy's annual speech relating to the progressive reforms as well as the Tantarine immigration in Acorn, California. The two political groups represented as the EFA and the OA disagree on the idea of the Tantarine migration into the city of Acorn. Unfortunately, this results in a tragic death for Thompson, to which my client, Casey Davidson, was wrongly accused as a perpetrator of. The subject of this motion is whether the government obtaining Mr. Davidson's car GPS data from the GPS provider is a search under the Fourth Amendment. Casey Davidson's GPS data is, and most definitely should be, protected by the Fourth Amendment. Because the Fourth Amendment states, and I quote, "It is the right of the people to be secure in their persons, houses, papers, and effects." Today, online data would be considered property and effects under the Fourth Amendment, meaning it is incredibly important for it to be secure. In the case,
Excuse me, why is it considered, why is that kind of data considered to be property or effects?
I believe that it's under considered property and effects because under in the case United States v. Jones, the court has stated a vehicle is encompassed by effect in Fourth Amendment.
In Jones, the police put a device on the car. Did that happen here?
No, but I still believe that it's encompassed under effects because whether or not they place the tracker on the car or not doesn't really have to do whether or not it's encompassed by the effects under the Fourth Amendment.
And kind of to follow up on that point, the government obtained the GPS information directly from the provider. Why shouldn't we consider that as the basis by which the government, under the Stored Communications Act, should be able to obtain this information?
Well, because wait, could you repeat the question again?
Well, the idea is that the information was obtained directly from the company, the third-party provider, right? It wasn't wherein the government actually searched the individual directly. They actually went to a third party who had the records of this GPS information, and under the Stored Communications Act, they were able to obtain it through a law that had been in place for years. Why should we, I guess, change the process now? I mean, it seemed like a fair process.
Well, the third-party doctrine was used to gain information like in that method, right? But at the time that it was created when digital information wasn't as commonly used or as popular as it is now. And I believe that using the third-party doctrine and then allowing the Stored Communications Act to work on this case would allow the government to take way too much private information from the consumers of devices.
Did Mr. Davidson know that his car had a GPS device in it?
Yeah, he did, but again, like, I want to state that the GPS company had said that that they keep and retain this location data to help them improve features of their products, and they specifically state it's to improve their products. They haven't yet stated that they're going to be giving up their information, giving up Mr. Davidson's information and giving it to the government.
Why is it Mr. Davidson's information and why isn't it the GPS providers, given what you've said about what the GPS provider says it's going to be using the data for?
Well, yeah, but the GPS couldn't be turned on or off. So it's either Mr. Davidson uses his car and allows the GPS company to take the GPS information and, again, improve their products, or he doesn't use a car at all. And especially because this case is located in California, California is a really technologically advanced state. Almost every single person or most of the citizens in California own a car, and allowing the GPS company to just provide the information that was Davidson's that could not be turned on or off is a violation of his rights.
Is it clear on this record that Mr. Davidson didn't have the option of turning off or getting a car that didn't have a GPS device in it?
Yeah, his car's GPS could not be turned on or off.
Does it matter that people could just look at his car and see where the car was going?
They can see where he's going, but like, okay, we have a car on a street and you can see that the car is on this street at this time, but they don't know where Davidson is going. They don't know where he'll be going and how long he'll be staying there. And I believe that that information should not be given to the government.
You know, unlike some of the other cases like Davis, where the monitoring, it was 67 days, and Graham, where there was 221 days of monitoring and the court found no violation. My understanding is 2 weeks in this circumstance. Why shouldn't we consider the relative short amount of time that was requested with regard to the GPS information?
I want to first correct that this GPS data was taken from over 4 weeks, so that's around over a month. And I want to say that United States v. Davis and United States v. Graham, they're not binding on this court and shouldn't be taken as seriously as the other cases that I will be talking about later in this case.
Should we give you a rest and hear from the other side then, and then we'll proceed? Thank you so much for these arguments. Or do you have anything else you want to say first?
I have a lot more to say.
Why don't you go ahead and say some more things then?
Okay. 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 In the case of Katz v. United States, it was stated that a person has a reasonable expectation of privacy when first, a person has exhibited an actual expectation of privacy, and second, if society is prepared to recognize these as reasonable. Since Mr. Davidson did not voluntarily share his GPS data, the government should not be able to access this information because it is protected by the Fourth Amendment. While Mr. Davidson may have known that GPS companies had his locational data, he did not know the company would let the government access his private information so easily without even a warrant, especially when the GPS and satellite companies alike specifically state that they keep and retain this location data to help them improve features of their products. In no way do they state they were using the information to hand over to the government. So because Mr. Davidson did not voluntarily share his location information, he has exhibited an expectation of privacy.
Is his sharing of information less voluntary than the bank records in Miller?
Yes, because in United States v. Miller, the bank records were physical information, and this information is digital information.
Why does that make a difference to whether it was voluntary sharing or not? You talked before about how difficult it is to get by without a car and the fact that the GPS device couldn't be turned off. But if you want a bank, then you're sharing financial information with a bank, whether you like it or not. So what makes the sharing of information in Miller less voluntary or more voluntary rather than the sharing of data here?
Yeah. Well, when you have like public records, or like physical records, it's a lot easier to get your hands on, especially because in Miller, the defendant had chosen to give his information to this bank directly, whilst in Casey Davidson's case, he didn't directly say to the GPS company that you can have this information. He went through the process of getting his car from the car company and not specifically the GPS company. May I continue? Let's go ahead. Okay. Furthermore, we know that society is not prepared to allow searching through digital information without a warrant legal. In Riley versus California, the Supreme Court ruled that not every search is acceptable solely because a person is in custody. Today, over 90% of people own cell phones, and these devices create a digital record of nearly every single aspect of their lives. The search of a cell phone would typically expose to the government far more than the extensive search of a house, so generally a warrant is required.
Doesn't the search of a phone, though, show pictures and what you might say to your parents and what you might say to your spouse? Whereas location data is much less personal than that, isn't it?
Yes, but digital information is still private information, whether or not it gives as much information as, like, either. Digital information is still digital information, and it should be private, whether or not the cell phone data gives more information and the GPS information gives less information, because knowing Davidson's location still gives away a lot of his life, like his lifestyle and his daily routine, and that's not something that he wants to be shared to the government.
But he could just have been followed by, say, a surveillance vehicle.
I don't believe he could have been, because this was data from over 4 weeks, and that's pretty hard to do, to follow him for 4 weeks straight, 24/7.
I think we should give the government a chance soon, so why don't you wrap up your comments?
Okay. Your Honor, if we allow the government to search the GPS data without a warrant, we will be leaving a precedent with drastic consequences. Taking modern era GPS location or cell site location information and saying that customers turn over the information voluntarily will give the government broad authority to track almost every single aspect of people's lives. Not only will they be able to track people's locations without a warrant, the government will be able to track personal emails, sell our location information, even down to the simplest things like purchases from Amazon. Privacy regarding modern technology is a reasonable expectation the society should be able to expect. Thank you for listening.
Let's hear from the state whenever you're ready.
Your Honor, may it please the court. My name is Ria Tiagi, and alongside my co-counsel Isabel Ranke, I represent the people in this case. The prosecution requests the denied defense's motion to suppress the GPS evidence obtained in today's case. The prosecution would like to assert that first, in connection with the Stored Communications Act, the order was proper. During the Alex Thompson homicide, the police received a tip that linked the defendant, Casey Davidson, to the murder of Mr. Thompson. This tip uncovered information revealing that several weeks before the Thompson homicide, the defendant was found outside Mr. Thompson's home. Later on the day of the murder, the defendant's walking stick was found at the scene of the crime, causing Detective Adrian Carroll to pursue a court order under the Stored Communications Act. The Stored Communications Act clearly states that all the government needs to pursue records from third-party venues is A, reason to believe those records are relevant, and B, that they're material to an ongoing criminal investigation case. In this case, the ongoing violence between the defendant and the victim and the witness statements putting him in the vicinity of the victim's home repeatedly make this both relevant and material. Therefore, Your Honor, in this case, there's no doubt that that information has met the standard.
And in fact, that's not actually a disputed issue, is it?
I would guess not, but just to state that there is the Stored Communications Act, which makes the search it makes it not under search under the Fourth Amendment. May I continue? Second, there was no need for a warrant because Mr. Davidson had no reasonable expectation of privacy. He clearly submitted his information to a third-party GPS provider, thereby waiving his right to reasonable expectation of privacy. When the defendant bought the car, the GPS was already inside the vehicle. In the 21st century, GPS is ubiquitous, and the claim that the defendant did not know what he was buying and further did not know the GPS was included is unreasonable.
Would he have known that it was being stored, though? I mean, just because there was a GPS, maybe that could help him have a map to find out where Safeway is, but it doesn't necessarily mean the company would keep track of the fact that he went to Safeway.
It's been found in several cases that by using the GPS, he's submitting his expectation of privacy, right? By using the GPS company to navigate from place to place, they have to store that information somewhere. And so when they store it through the third-party venues in cases like United States versus Knott's, it's been held that because he's giving that information to third-party venues, he has no reasonable expectation of privacy.
Knott's doesn't go to whether a third party is storing information.
Well, Knott's has to deal with the information on a public thoroughfare. And in that case, it deals with the car and where it's going, right? And sorry, I'm getting a little nervous. Sorry, can you re-ask the question?
So I didn't recall Knott's being so much of a third party case, and you were saying earlier that the fact you were asking us to rely upon the fact that Mr. Davidson would have known that there was a GPS device in the car. So backing up just a little bit, would you agree then that Mr. Davidson didn't necessarily have a choice about whether there was a GPS device in the car?
No.
He didn't have a choice. And then as far as the data, I mean, if you're using the GPS device, is it so clear on this record that Mr. Davidson would have known that not only was the GPS navigator assisting him in finding a particular location, but that the third party was actually maintaining a database on him in terms of storing all of his location information for all of this time?
I'm not sure I understood the question, Miss.
I'm just wondering whether Mr. Davidson knew not just that he had a GPS device, but that the GPS provider was not just tracking where he was going in the moment, but was keeping it.
Mr. Davidson, we don't know if he knew that the GPS was tracking the information, but by buying the car and using it throughout the course of the time that he had been, he assumed the risk inherently of his information being shared. We don't know whether or not the GPS, or whether he was using the GPS or anything else. All we know is that based off the information in the closed library that because he was using it, that this is stored, right? And the only reason that any of this information can even be used is because it's been found to be both relevant and material.
Well, and when kind of following up on Judge Friedland's question, shouldn't we be looking at this more like the Supreme Court did in Riley, where the court found relevant that 90% of people own cell phones. And it creates a digital record of every aspect of one's life. And why aren't GPS information in vehicles, as we have here, kind of a similar circumstance, that we should be concerned about the government, without a warrant, being able to track wherever you go and who you associate with? Why shouldn't we be concerned about that with this current process?
Well, the case in Riley deals with digital data, whereas this has to deal with his GPS tracking. And so it was stated that the search of a cell phone would typically expose far more to the government than the most extensive search of the house. But in this case, we aren't evaluating the privacy of a cell phone in the Davidson case, right? And so the GPS data in Davidson's car was collected whether or not he was aware of that. And in the case of Riley, it's been found that a phone collects more extensive data than a GPS. And so the ruling there would apply a little bit less. May I continue? The Supreme Court has held that people who give information to third parties, such as banks, phone companies, and internet service providers, have no reasonable expectation of privacy. This is called the third-party doctrine. This is outlined in several cases within our closed library, including United States versus Knotts and United States versus and Smith v. Maryland. Just like in Smith v. Maryland, where the defendant's dialed numbers were not considered a search under the Fourth Amendment because they were voluntarily transmitted, Davidson's GPS location falls under the same principle. In both cases, the defendant voluntarily conveyed information to third-party entities. Therefore,
If we agree with you, would that mean that if someone wants to keep their privacy, they can't drive anywhere?
well, I wouldn't equate those two. It's not like Mr. Davidson was in an area that was traditionally protected, right? The areas that he was on, that I'll discuss later in my spaces, they were on public thoroughfares. And so his expectation of privacy is less on public thoroughfares.
To find weeks of information about where he went, though, someone would have to stay up all night and follow him all the time. Is that actually something that we expect people will do on public thoroughfares?
Can you reword your question?
So even if people can see where he is because he's on a public street, to actually follow him for weeks the way that the GPS did, someone would need to stay awake a lot because they'd have to follow him all 24 hours a day. And we don't usually think people are capable of doing that. So it seems like there's more of a privacy invasion from allowing this GPS data to be taken by the government than just letting someone see you some of the time on the street.
Well, I mean, they could do it like that, but what Knotts has held is that anything on public thoroughfare itself is not private. It's all public. So I guess regardless of whether they were visually surveilling it, the fact that it was on public thoroughfare mitigates his expectation of privacy. Does that answer your question?
And I appreciate that you distinguished Riley from this case. I guess my other issue is the fact that particular GPS, you can track who individuals are associating with. And so in this case, it looks like the defendant's car was seen at least 7 or 8 times at the RADS meeting. And my concern, without using the probable cause standard, it might chill people's willingness to associate with other community members who may be unpopular, right? And so why shouldn't we keep that in mind, as the courts have always indicated that we should, in terms of protecting individual rights to associate with others and not have to worry about government abuse of the law?
Well, it's not like Mr. Davidson's evidence or his GPS locations were just searched randomly because it was found to be both relevant and material to an ongoing criminal investigation case. That's why the court order to the SCA was provided. It's not like anyone who's just going to different meetings, they're going to have their information being tracked. I mean, if they're using GPS, like in this case, they will be tracked, but it won't be a part of a criminal investigation case. Like as in today, because he was voluntarily submitting that information, and also he had past violence and past situations with Mr. Thompson, it was already found that he had a linking.
Well, but again, my concern, I mean, we have to be mindful of the history in our country where at different times the government has targeted particular groups and has used their ability and access to information to chill speech, chill association. I guess, again, in this circumstance where there's a lower standard being utilized to obtain information, why shouldn't we be concerned about that?
Because again, both had to be reasonable and material. So because of that, and because not only had they got into physical altercations, but Mr. Davidson's walking stick was found covered in blood at the scene of the crime. And so in my mind, that wouldn't be an abuse, right, on the government's part. To me, that would signify a significant probable cause. And yeah.
Thank you.
Can I continue?
Yes, and I think we've been asking you questions a long time, so if you want to wrap up, go ahead.
In Knott's, the court has ruled that the tracking beeper did not constitute a search under the Fourth Amendment because the same information could have been obtained through visual surveillance on public streets and highways. This is significant because individuals have no reasonable expectation of privacy when they're in public areas. Similar in our case, the GPS data obtained by law enforcement showed his location in public spaces such as streets and highway. Since individuals do not have a reasonable expectation of privacy in such public areas, the gathering of Mr. Davidson's GPS data does not qualify under a search under the Fourth Amendment. However, even more recently in the Federal Circuit Courts 3, 4, and 11 of our closed library, it's been ruled that all disclosure of cell site location information is not protected under the Fourth Amendment. A clear example of this is United States versus Graham. Davidson had no reasonable expectation of privacy in the GPS location data, just as in Graham, where the defendant's historical cell site location information was obtained as part of an investigation. The GPS collected in this case, was collected in the ordinary course of business. This lack of expectation of privacy extends from voluntarily transmitting location data to third-party service providers. And the same is true here. The defendant voluntarily gave the information to a GPS provider and therefore had no direct control over where that information was being distributed. It's been held in United States versus Knott's that the Fourth Amendment does not protect any information placed the defendant on public thoroughfares. All 12 locations on Exhibit J placed the defendant on public thoroughfares. None of this information was obtained in a traditionally protected area, like a home or hotel. Therefore, the claim that there's a reasonable expectation of privacy does not stand. Additionally, the defense uses two main cases to support their claim, United States versus Katz and Riley v. California. In Katz v. U.S., the Supreme Court held that a person has a reasonable expectation of privacy in a phone booth because they've taken steps to ensure their conversation is private. However, in this case, Mr. Davidson did not take any steps to ensure the privacy of his location. In fact, he assumed the risk of his information being given to the GPS company, making it public. Moreover, we need to acknowledge that how the Riley v. California case does not apply to our case at bar. The Riley case shows how digital information was seized by the police and digital data was taken wrongfully. It was stated that phone information would typically expose more information in the government than the most extensive search of the house, but we aren't evaluating the privacy of a cell phone in the Davidson case. The GPS data in Davidson's car was inherently public. Additionally, a phone collects much more extensive data than a GPS, hence making it more personal or private to the defendant in this case. Bringing up the issue of the Riley case doesn't relate to the privacy issues of Davidson's car. Your Honor, this is why the prosecution requests that Exhibit J be moved to trial.
Thank you very much for your arguments.
Your Honor, may it please the court, I'm Michelle Lee and I'm in defense of Casey Davidson. The third-party doctrine should not apply to this trial since Mr. Davidson did not have an option to choose whether or not the car's GPS tracker could be turned off or not. The GPS provider said they will only use the GPS to improve their product and never said they will give away Mr. Davidson's information to third parties such as reapplication for telephone information where consumers don't share their information. In regards to the Stored Communications Act, although there's a court order, the GPS data is still considered a search under the Fourth Amendment due to an absence of a warrant. I'd like to reinforce the fact that cell phone data and GPS data are comparable in the ways that they both share detailed information about a person's public life.
If it was only 1 hour of GPS data, would you have the same argument?
No, but in this case, it was over a 4-week period, so that would not apply. Can I continue? The prosecution brings up US v. Knott, stating that following Mr. Davidson's car on public roads would have given the same amount of information as the GPS would have. This was true in US v. Knott since they only needed the data from the place of purchase to the defendant's house. But in our case, Mr. Davidson's GPS data was taken over a 4-week period, and obtaining this information without GPS data would be very difficult. Additionally, the prosecution claims that Mr. Davidson did not have a reasonable expectation of privacy. However, this is false due to how in US v. Katz, both defendants were in a closed, restricted areas where those around them wouldn't be able to see or know what they're exactly doing, giving them the feeling that it was what they were doing was private. In Smith v. Maryland cannot apply it to this case since the sole reasoning for their holding is that the defendant in both cases voluntarily gave up their information, which allowed the government to obtain the information while Mr. Davidson did not and could not have chose to have his GPS tracked. As well as in US v.
In Smith, could the person have made phone calls without the pen register have recording the phone numbers?
Could you repeat that again?
Yeah, in Smith, so you said that Smith involved voluntary conduct and this didn't, but the phone calls in Smith that were on the pen register, could you have made phone calls without them being on the pen register?
No, but the case explicitly said that it was voluntary. Therefore, it shows that the defendant in that case, in some way, chose for it to be tracked.
I guess making the phone call was voluntary, but would we say that driving was voluntary here?
In a way, it was, since in California, which is the place where this case is being taken place in, is very difficult to get around without the use of a car. So yeah, in a way, they would have to use a vehicle. The usage of a vehicle wouldn't necessarily be involuntarily.
Similarly with the phone call, though, depending upon the distance to the person that you're calling, it's hard to communicate in real time without using the phone, right?
Yeah.
So is this really less voluntary? Is Mr. Davidson's driving the car with the GPS that much less voluntary than the phone calls in Smith?
I would like to re-emphasize that the GPS data could not be turned off. So I would like to discuss that his would you say it again?
So is what you're saying basically that in Smith, you can make a call and then your call is over. And whether or not you choose to make another call after that is your choice. But you're saying that in Mr. Davidson's case, the GPS is just always on, can't be turned off. So it's always tracking his location.
Well, yes, it's always tracking his location, but what would you say about Smith v. Maryland about the call?
I think I was just trying to get at an ability to compare how much more or less voluntary the tracking of location is in this case compared to the tracking of phone calls in Smith.
Seeing that in Smith v. Maryland, it said that was voluntarily, they probably chose to have their information held by the third party providers. Seeing that.
Let me ask a question about the distinction that you've been making here. One of the things that I found in the cases where there was a Fourth Amendment violation, there seemed to be, the defendant had an ownership interest in what was being searched. So, for example, with Riley and the phone, what's the ownership interest that the Mr. Davidson has in the GPS information? Like, it's not his, is it?
What is his, since it's it details about his like where he has gone and exactly where he has been for this like for very and it details about the exact time of like his location.
But wouldn't the company argue that that's their information? They're the ones collecting it. They're the ones storing it.
They do collect it, but they cannot use it however they want, since their model was that they can only use it to improve their product.
Been asking you a lot of questions. You want to wrap up your rebuttal?
Yeah. As well in US v. Graham, as well as in the US v. Graham case does not apply to our case since the defendant in that case shared their information while in our case, Davidson did not. These cases were very different, therefore they have different outcomes. As well as the data in this case was still taken when the vehicle was not used, while in William Graham it was only taken when it was being used. I'd like to restate and emphasize that the invasion of Davidson's GPS information was a search under the Fourth Amendment, under the word effects, and a warrant wasn't given. While the prosecution argues in agreement to the Stored Communications Act and the third-party doctrine, those rules are less powerful and given less authority than the U.S. Constitution. In these trials, we need to prioritize the rules and regulation of the U.S. Constitution as it has the highest authority. If the Stored Communications Act and the third party were to apply, the search needs to still comply with the Fourth Amendment. Your Honor, if we allow the government to search through the GPS location information without a warrant, it would give them the power to search every aspect of a person's life. With the changes in data and privacy over the years, users have a reasonable expectation given how much information it tells about a person.
Thank you.
Your Honor, the prosecution would like to address the arguments made by the defense in their motion to suppress the GPS evidence obtained in this case. The defense has cited the cases of Katz v. United States and Riley v. California to argue that the use of GPS data in this case violates Mr. Davidson's Fourth Amendment rights. However, these cases are not are applicable to our situation at hand. Additionally, they cite that there was no probable cause for the SCA to be obtained. However, not only was Mr. Davidson's walking stick found covered in blood, but also there was witness statements by Morgan Bonderman. In Katz v. United States, the Supreme Court held that a person has a reasonable expectation of privacy in a phone booth because they have taken steps to ensure their conversation is private. However, in this case, Mr. Davidson did not take any steps to ensure the privacy of his location. In fact, he assumed he did that. Can you repeat that?
How could anybody take steps to ensure the privacy of their location with the GPS device that's already on their car that they can't turn off?
Mr. Davidson could have just not used the car either way. So that means he could have just, so his GPS, his location would not be tracked if he just didn't use the car either way.
So in Katz, couldn't the person have just not used the phone booth?
Yes, but in this case, we are talking about GPS data, not phone numbers being dialed. May I continue or any further questions?
I guess my follow-up would be implicit, in Katz, it seems like there's a presumption that you can use technology, and that doesn't necessarily mean that you give up all rights. Just the simple choice to use something, in that case, a phone booth, doesn't mean that you give up all rights to privacy around that. And you've made the point that in Katz, it's a phone booth, you can shut the door, there's some at least appearance of privacy. And you said that Mr. Davidson didn't do any of the things that Mr. Katz did to demonstrate that he expected privacy in his location.
Well, also, there's also the fact that also he drove on public welfare, as in public roads. So that means anyone who ever cared or was just wandering around could see where he was going, and therefore he was. So that means there's no reason of privacy when he was out in the open where everyone is looking. However, with cats, they were in phone booth where no one could really see them. But however, with Davidson, he was out in the open where everyone could see each other in their own car. So there is no reasonable expectation right there. And also, he was driving on public road.
Well, in Jones, a GPS tracking device was placed on an SUV for 28 days, and the Supreme Court found that the placing of that tracking device was a Fourth Amendment search. Why isn't that similar to what information that's being obtained here? I mean, this was over 4 weeks, as I was corrected earlier. Why isn't that important for us to consider?
May you repeat your question or maybe simplify a little bit more? I didn't quite understand your question, Your Honor.
Well, I'm looking at Jones. And Jones was a case where the police placed a tracking device in the defendant's vehicle, and it was placed on that and remained on the vehicle for 28 days. The Supreme Court found that it was a search pursuant to the Fourth Amendment, or under the Fourth Amendment. And what I'm wondering is, in this case, we have a circumstance where the police are obtaining very similar information with regard to where an individual is coming and going, and but you're indicating that this is not a Fourth Amendment search. Why should we make that the distinction you are?
Well, because there is number one, there's no warrant, but there is a court order, and that is different than a warrant, where with a warrant that's where you need to have a search. And this is not a search under the Fourth Amendment because he was on private road. And the Fourth Amendment protects people, not but hold on a second. Going back to what I said. That's like,
It sounded like you were going to say that it protected
yeah, I
people,
would-
not necessarily places, but why shouldn't we be concerned that the government is tracking the people to those different places? I mean, we talked earlier about the fact that when people move around and, for example, they associate with other individuals, it's providing a lot of information to the government that ultimately could be abused, utilizing a lower standard under the Stores Communication Act. Why shouldn't we be concerned about that?
wait, can you repeat your question?
Well, I guess what I'm trying to get from you is, it seems like the government is okay with using a lower standard to get the information that's being obtained here. And my concern is, with the lower standard, utilizing a reasonable grounds as opposed to probable cause, might open the door for the police to be able to just arbitrarily say, well, I don't like this group or I don't like this person, so I'm going to just ask for a court order and see what they're doing. I'm concerned about that. Why shouldn't I?
The police should only do that only if there's an ongoing criminal investigation, just like with the murder of Thompson and Davison being linked to it. Therefore, that information was needed. I'm not trying to say that the government should just take it whatever they want to, but only when it's necessary when there is an ongoing criminal investigation. May I continue?
Yes, and we've been asking you a lot of questions, so go ahead and wrap up whenever you're ready.
Or let's track. I'm not sure where I left off, so I'm just started. Is that okay? Okay, sorry.
Go ahead and wrap up however you.
Davidson had no reasonable expectation of privacy because he voluntarily transmitted his location data to the GPS provided by using a GPS device. This means he actively chose to share his location information with a third party, which diminishes his expectation of privacy. By using the GPS device, Davidson essentially consented to sharing his location data, making it difficult to argue that he had reasonable expectation of privacy. Furthermore, it has been pointed out that the Fourth Amendment does not protect information that was given to a third party without reasonable expectation of privacy. There is no privacy given to the location of the car on a public street. Mr. Davidson's location was visible to anyone who looked. Additionally, the defense made claims that are ill-fitted to this case. They stated that Mr. Davidson's location was private, but this does not make sense as it was on a public street. We have United States v. Knotts in our case to defend this claim. The prosecution has also given clear reason as to why Mr. Davidson's data had no reasonable expectation of privacy, and we have provided several cases, including United States v. Davis and United States v. Knotts, to explain our stance. The defendant voluntarily gave this information to a GPS service provider and therefore had no direct control over where that information was being distributed. All 12 locations on Exhibit J placed the defendant on public thoroughfares. None of the information obtained places Mr. Davidson in a protected area like his home or a hotel. Therefore, the claim that there is a reasonable expectation of privacy does not stand. Additionally, United States v. Jones does not stand as it went outside of the scope of the warrant. Additionally, in Jones' case, the FBI physically attached a GPS tracking device to the defense vehicle without a warrant, constituting a physical intrusion and violating his Fourth Amendment rights. This does not apply here, as he continually conveys his information. Moreover, we need to acknowledge how the case of Raleigh v. California 2014 does not directly apply to the case at stake today. The Riley case shows how digital information was seized by the police and digital data from a cell was taken wrongfully. As explicitly mentioned, the search of a cell phone would typically expose the government far more than most extensive search of a house. But we aren't evaluating the privacy of a cell phone in the Davidson case. The GPS data in Davidson's car refers back to the GPS within his car and not a cell phone that was seized from the police. At the time it was collected, Davidson had not been arrested either. So when the defense is attempting to relate this information of a phone to the GPS data found within Davidson's car, the connection cannot be made. A phone collects much more extensive data than a GPS, hence making it more personal or more private to the defendant in that case. Bringing up the issues of Riley's case does not all relate to the privacy issues of Davidson's GPS within his car, as the car's GPS does not even compare to the information found within a phone. Nonetheless, a phone seized unlawfully after the defendant was arrested. Additionally, the third party doctrine states that that individuals have no reasonable expectation of privacy in information shared with third parties. This legal principle applies to Davidson's case. Because he shared his location data with the third party GPS provider, by doing so, he lost any reasonable expectation of privacy in that information. The third party doctrine is based on the idea that individuals assume the risk of disclosure where they share information with third parties, which is why we would like to reiterate, Your Honor, that in this case we should move to trial. Thank you.
Thank you very much. Let's have a round of applause for all of the students. So I think we're going to give some feedback now. Would you like to go first?
Sure. I thought you all were excellent. I was trying to think back when I was in high school and the prospect of getting in front of 4 judges, I wouldn't have imagined it. And the fact that you all stood in front of us and made such amazing arguments, citing cases, I thought you all did a wonderful, wonderful job. I would encourage you all to continue with this process. I mean, the thing I learned over the years is that you get better by more opportunities to do this. And I see in each of you kind of, at different places in your presentations, I could really tell at different points you were really getting into your argument. Because a lot of these cases, I mean, this case being no different, we're trying as judges to get the right answer, right? We're oftentimes dealing with issues that no one's dealt with before. And we want to make sure that we're trying to find an answer to very perplexing questions. That's why we need great future lawyers like you to work on, helping us arrive at those answers. So, but you all did a wonderful, wonderful job. You should all be very proud of yourself.
Thank you, Justice Wilson. How about Justice Lee? Oh,
So I want to echo Justice Wilson's comments. I thought that you were all very, very impressive, exceptionally well prepared. You've clearly done a lot of work on your prepared statements and also invested a lot of time in knowing the cases, in anticipating questions, and also in anticipating what the other side was going to argue. So very, very well done. And then for individuals, I just wanted to share a couple of things that I really appreciated about each of your arguments. Hilda, I thought that, even though you're very soft-spoken, you were also very assertive. You weren't shy about pushing back when you needed to, whether that was to say you wanted more time and you had a lot more to say, or I know I asked you a question about, whether certain information could really be considered public, and you really stood your ground in a very respectful, quiet, but appropriately assertive way. Ria, I thought that you did a fantastic job of maintaining your composure, even when you weren't quite sure where the questions were going, or even maybe what they were, because we judges don't always ask questions in the way that's most clear because we're kind of operating off the cuff too. And I also thought that you pushed back very nicely when I think it might have been Justice Wilson was asking the question, basically comparing Riley and the cell phone data and the whole Pandora's box that potentially represents. And you're saying, no, I wouldn't go so far as to say that. And distinguishing the GPS data from the much broader scope of information that was in the cell phone. And Michelle, I think, you had an unexpected challenge when you first hit the podium because it was not made for people our size. And you didn't let that faze you at all. And also when you got the microphone handed off, I mean, that's the sort of thing can really throw people off in the midst of things. And you didn't miss a beat. And I also thought, independent of just sort of the physical challenge that was thrown your way unexpectedly, you made a very subtle point, I thought, about the hierarchy of authority and the difference between a statute and the Constitution. And I thought that was very deftly done. And then Isabel, I thought that the point I thought that you made that was really critical was you had heard both in your own argument and also in the arguments of your colleagues that Justice Wilson was really concerned about the policy implications of all of this and about the sort of how much further this could go. And you and Ria had clearly thought about this in advance, and you hit it really well when you said, there's still a court order. We're not talking about giving the police license to just do what they want unchecked, but there's a court order, there's oversight. And I thought that was an excellent point to make, and a particularly good one to be ending on in your rebuttal, because you'd heard that there were these concerns all along. So all of you, had a number of things, and those are just a few of the things that I noticed that I wanted to really compliment you individually on.
So I agree with all of the comments that have been made here on the bench. I would like to add a few things. You all were tremendous. It was so wonderful to watch you. And for anyone in the room who hasn't been at a podium like this answering questions from judges before, it is very, very hard to listen to the question and actually try to answer it. When you're nervous and you're up there and you're thinking about the points you want to make, it's very hard to understand what questions are being asked. And all of you did a great job of actually hearing our questions and answering them. And when you didn't know exactly what we'd asked, you asked us to ask again. And that showed confidence, and it showed that you were thinking about the issues, and you had great answers. And that is it's a very difficult thing to do. And you all are you're on a great trajectory already being able to do that. We don't always see lawyers who know their cases as well as you guys knew this case, and it was really a pleasure to watch you think up there and make great points about this case. So watching you just gives me tons of hope about our future, and I think you all have tremendous futures ahead, and we are very excited to see where you end up. And it's really fun to see someone who we watched do this before, who's further along the path and is doing great. And I am very optimistic that you all will be in similar shoes in several years.
Thank you again, judges, and thank you again, students. And we give them another round of applause, please. They did a wonderful job. And to cap it off, I would love to give them some awards before we hear feedback. Obviously, let's celebrate them a little bit more. So, Hilda, would you please come up and get an award for coming and being a part of this Moot Court experience? Thank you so much, Hilda. Would you all believe she's in 9th grade? Yes. Congratulations, Hilda. Michelle, come on up. Wonderful, wonderful. Another 9th grader, y'all. More time in Moot Court to come. Okay. Isabel? Congratulations. We really appreciate you and all that you've done here today. Thank you. Thank you. And last but not least, Ria. Thank you for participating in the People versus Davidson Moot Court event. Oh, thank you. Let's get a round of applause. Thank you. So I know that we said we would be ending at 7:15, but I wanted to give the judges an opportunity to kind of explain their thought process and also share something really interesting about this case and something that was decided not too long ago. Would you like to take a minute or two to just express what your decision would be and kind of give a little bit of feedback about that?
So this is a closed library case. We're only deciding this based upon the cases that have been given to the students. If it were up to me based solely on those authorities, then I would be voting to deny the motion because I think up until 2018, the third party doctrine was alive. And if the government was getting your data from a third party, that was kind of the end of the story. It didn't matter how reasonable your privacy interests may have seemed to you. The fact that you gave that to a third party or allowed a third party to have it, that was kind of the end of the story. And then shortly after, I think this fact pattern was written, the Supreme Court decided Carpenter versus United States and said, not so fast. But it was a split decision. It was 3 justices ago. It was split 5-4. And every one of the 4 dissenters wrote a separate opinion. And some of them felt that Katz was wrongly decided and that we really needed to go back to a property-based view of the Fourth Amendment. Some of them viewed Katz as being limited, even if you didn't consider it to be wrongly decided. And so the third-party doctrine should apply. And then one of the justices just said, well, it doesn't really matter. Katz doesn't fit anymore. But the majority's view is wrong anyways. And so there must be some other way of resolving these things. And Mr. Carpenter hasn't brought that to us today. And there's more to be decided, basically. And, you know, what the Supreme Court would do with GPS data rather than cell site location, which was at issue in Carpenter, what they would do today, I will not try and guess.
Carpenter, the GPS was basically in your phone. So part of the idea in Carpenter was you really need a phone to function in modern society. And so if you're going to have your phone, it's going to be tracked by the cell towers. And so it's essentially the same as this GPS data. I think we all talked today about how important a car is. And so you can imagine the same reason, I think the same reasoning that it's hard to drive a car. So if the car is going to have a GPS, it becomes a lot like the phone. But it is interesting to see this problem wasn't written that long ago. And so it's interesting to go back in time a little bit and hear all the arguments that the Supreme Court had trouble answering. So you guys had great arguments that are all the same things that they really struggled with too.
No, I mean, and we're still, in addition to some of the future issues that I think you can imagine, there have been discussions about, for example, facial recognition, right? I mean, whether we have an expectation of privacy in our faces. I remember when, the programs at the airports came out and you could get through the lines faster by signing up for different programs. And, I went ahead and signed up and gave my face and biometric information. I turned all that information over, not knowing that goes into a database that at some point the government might decide, well, Mr. Wilson went ahead and gave this up to the clearer company voluntarily. And so to the extent that, you put my face into a system and everywhere I go now, in terms of the cameras on the streets can pick up my face. We don't know how the courts are going to deal with that process and AI that is obviously is a part of our conversation now, how what people's reasonable expectation of privacy may be deemed to encompass in light of the upcoming technology. So you're all on the forefront of these discussions today. So congrats to you for that.
Thank you. I want to say thank you so much again, judges, for being here, and thank you everyone else for being here as well. And with that, I want to return the rest of your evening to you. We want to thank everyone who has supported us throughout the entire time, our legal advisory committee, members of our board. I want to thank DLA Piper and Carrie Williamson so much for being here and letting us use your space. Thank you to my fellow staff. Thank you to the parents and the community that we all have out here. And thank you to the students as well. We really appreciate everyone coming together and making this happen. I really appreciate all of you, and I look forward to seeing you all again in the near future. Please have a wonderful evening.